My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law, so please subscribe to our channel. Can you avoid a 50-50 split in a high asset divorce? Well, I suppose the answer is yes, depending on where the high assets came from and when. You see, if you accumulate a lot of assets during a marriage, the court is generally going to look at it as if both parties contributed in one way or another to develop that. Maybe you both worked the business. Maybe only one of you worked the business while the other one took care of the kids so that you could work the business. But the point is, if it's accumulated during the marriage, the general proposition is you're looking at a 50-50 split. If there are assets that were accumulated that are high assets but they started before the marriage, that's a different story. If the asset existed before the marriage, then there's a calculation to be done. A valuation which would say, look, before the marriage you had this company, okay? It had a value of $5 million. Now, during the marriage, it has gone up, it's worth $7 million. So we have a $7 million company, we're not dividing the $7 million company because $5 million of that you had beforehand. At most, what we're going to look at is the growth, the $2 million that accumulated during the marriage. That would be something that might be part of the discussion in a property settlement. In a high asset divorce, you also have to look at other things. Sometimes the assets aren't owned just by husband and wife. Sometimes there are other partners. Sometimes there are corporations that own the assets. So there's different things to look at in terms of that. But the general proposition is if you do own the asset and the asset was accumulated during the marriage, that is the piece that is in play for division. If you have any questions about that, reach out and we'll be glad to help you.